I'm Lauren Kaeseberg, and today I'll be talking about the leading causes of wrongful convictions. As part of our work with the project, we are a member of the Innocence Network, which is a national organization of all the innocence organizations across the country. And so we've all put our heads together to try to figure out what are the leading causes of wrongful convictions. What we've learned is that the leading cause of wrongful convictions is eyewitness misidentification. There's very little that's more powerful in a courtroom than a victim or a witness getting inside of the witness stand and pointing their finger at a defendant and saying that that's the person who committed the crime that they saw or that they experienced. And jurors don't understand, and the general public doesn't really understand that human memory is fallible. And we don't recall things in our minds as if they were recorded in a movie. But instead, little suggestions and seeing someone's picture, all these little things that happen during the procedure of identifying someone can really stick inside of a witness or victim's brain and in that memory. And while they may believe in good faith with all their heart that they're pointing that finger at the right person, we've seen in 70% of these cases that they're actually wrong. And another staggering statistic, I believe, is that in 60% of those cases where we've had an eyewitness misidentification lead to a wrongful conviction, the exonerated person looks very different than what the initial description was that was given by the witness or the victim. The second leading cause of wrongful convictions is faulty forensics or bad forensic science being used in cases. And what we see all too often is examiners in laboratories around the country and in this state being given samples from a suspect and samples from the crime scene at the same time, and then being asked to compare them and see if there's similarities or if there's a match. So we know that cognitive bias is entering that process. And in addition to that, we see overstated confidence by expert witnesses and examiners who will declare things to be a match or say things with such certainty, even despite the fact that there's very little statistical support or population studies to support their findings, to say that there's, 1 in 10,000 people would only have this bite mark, for example. There are so many problems with the area of forensic science in the courtroom. And what is an interesting thing that we've seen is that when you think about it, forensic science in the courtroom evolved and was created and developed in the courtroom. It's not a scientific discipline. Each separate area is not its own scientific discipline that was necessarily created outside the courtroom and then brought in because it could be used in the courtroom, like we see with DNA testing, which is known as the gold standard. But instead, these different forensic science disciplines really built upon themselves and grew within the courtroom. And so what you have is jurors who have what they call the CSI effect, where they want to see science in the courtroom. They want to see forensic applications of science. And when the state calls an expert witness to the stand who gets up there and says all of their credits and all of their resume and all of the scientific experience that they have, they're given incredible deference from the jury. And so we see it in 50% of the wrongful conviction cases where forensic science, unvalidated science, or overstated confidence has led to wrongful convictions. There's also development in our field over the last several years where we've seen 2 areas where science developments have shown us that there actually may have been no crime at all, not necessarily just the wrong person arrested for a crime or convicted of a crime. And we see that in arson cases and in shaken baby syndrome cases. So what we've seen with arson cases is that older investigative techniques from the 1980s, 1990s have really been questioned in most cases and invalidated in many instances. And there are many people in prison today based on arson science, which has now been refuted. We've seen the same thing with shaken baby syndrome cases, where you have a daycare provider or a caregiver of a child who was present at the time that a baby went into a coma or started displaying symptoms of what was declared to be a shaken baby syndrome diagnosis. We now know there have been countless studies that have shown that it's impossible to cause those types of injuries without some external indication of abuse. So we really believe that in the state of Illinois, as well as nationwide, in the coming years, there will be a surge of exonerations regarding shaken baby syndrome cases, as well as arson cases. And that's all part of this category of faulty forensics, which we expect to see continue to be a leading cause of wrongful conviction. The third leading cause of wrongful convictions is false confessions. And we see that in a quarter of the DNA exonerations in about 25% of cases. And to this day, even despite the number of people who have been exonerated by DNA evidence and otherwise who had false confessions, many people still believe that they would never confess to a crime that they didn't commit. So it's another thing that's incredibly powerful for juries to see. What we've learned is that there are certain groups of people who are more susceptible and prone to give a false confession. And from our perspective, innocent people are actually in that category to confess to something with the police. And that's because after hour upon hour upon hour of interrogation, of being stuck in a small room and just feeling like people are at a brick wall, many of our clients have said that they just felt like at some point they knew that these interrogators were never going to believe them. And if they just signed that paper, they could get out of that room, they could be with their families, they could talk to their own lawyers, and they could clear it up because they knew the evidence would never support the fact that they committed that crime. But as we know all too well, as it turns out, that confession many times is all it took really to seal the deal for those individuals. And in terms of groups of people who are more susceptible to giving a false confession, we've seen that with juveniles. Many times young people are not given access to their parents or to attorneys, and they are likely to give false confessions and want to give the authority figure what they're asking for. Another sort of interesting subset of the population that we've seen be prone to false confessions is actually Latino suspects. And at the Illinois Innocence Project, we have a Latino Innocence Initiative where we're looking really closely at cases involving Latino innocence defendants. And what we've seen is that not only language issues come into play when a Latino suspect is being interrogated, but all too often interrogators are able to exploit family relationships and threaten suspects with the deportation of their family members. And so we have suspects in the station who are willing to sign anything just to keep their families safe. And so we know that false confessions have happened in Illinois and Chicago. Most commonly we've seen with John Burge cases and actual physical violence used against suspects. But we know that it happens to mentally capable adults, and it can happen just based on exhaustion and sleep deprivation and just, like I said, being stuck in a room and feeling like you'll be able to clear it all up when it's all over. The next leading cause of wrongful convictions is seen in 15% of DNA exoneration cases, and that's informants and snitches or incentivized witnesses. So what happens often in these cases is a witness is brought in to testify or give evidence against the defendant, and they're being given something in return, whether it be early release from prison or the dismissal of charges pending against that person in that case or a different case. And oftentimes it's really just sort of the vague expectation of good treatment in the future. But unfortunately, those incentives are often not disclosed to jurors. So what happens is jurors see this person be called by the state, which gives them instant credibility, be brought up to the witness stand, swear to tell the truth, and they don't know the motivation behind why this person is saying what they're saying against the defendant. And so it's really a problem in these wrongful conviction cases, and there have been some movements towards trying to create a way to suss out those inappropriate motivations and those witnesses who are incentivized by doing reliability hearings and other things. But it's something that we hope in Illinois will see some changes in the coming years. And finally, the last leading cause of wrongful conviction that we see throughout all of these cases is government misconduct and bad lawyering by defense attorneys. So some of the government misconduct has already been discussed regarding eyewitness identification procedures or false confessions being given. But it also includes the failure to turn over evidence by police and Brady material by prosecutors. And in addition to government agents, we see in many, many cases just bad defense lawyering at the time of trial. Not doing full investigations or any investigations into the claims of innocence being made by the defendant. And many times it's an inexperienced attorney or someone who's overburdened by being a public defender with, way too many cases on their docket. And so what we want to do at the Illinois Innocence Project, and really collectively nationwide, is really shine a light on the fact that these practices can really lead to real consequences for innocent people. For more information on wrongful convictions and the reforms in progress, please view my full presentation recorded during the Hot Topics in Criminal Law program and available in the ISBA online CLE archives.